A SWAT team crashed through the front door of a suburban home at 6 a.m. Flashbangs exploded. Officers in tactical gear stormed through the house shouting commands. A man in pajamas was thrown to the ground, hands zip-tied behind his back. The team leader radioed back to command, "Suspect secured, residence secured." But then someone checked the address. They were at 4758 Maple Drive. The warrant was for 4785 Maple Drive. Wrong house. And the man on the floor? Federal Judge Thomas Brennan, a 25-year veteran of the federal bench who had presided over hundreds of cases, including several involving police misconduct. What happened in the next hour sparked a national conversation about police accountability, no-knock warrants, and what happens when law enforcement makes catastrophic mistakes. Many observers would later call it a turning point in the ongoing debate about police reform. Before we dive into this controversial story, hit that like button and subscribe so you don't miss more commentary on important issues like police accountability and civil rights. Now let's examine what happened that morning. Who is Judge Thomas Brennan? According to public records, Thomas Brennan was 58 years old and had served as a federal district judge for 25 years. Legal observers noted that his career had been marked by a reputation for fairness and a strong commitment to constitutional rights. Court records show that Judge Brennan had ruled on numerous high-profile cases throughout his career. Several legal analysts pointed out that he was known for being particularly strict about Fourth Amendment protections, the constitutional right against unreasonable searches and seizures. Critics of police overreach often cited Judge Brennan's rulings as examples of judicial pushback against law enforcement excess. In multiple cases, he had suppressed evidence obtained through what he deemed illegal searches. He had thrown out cases where he believed police had violated constitutional procedures. Some law enforcement advocates had publicly criticized him for what they called being soft on crime, while civil liberties groups praised him as a champion of constitutional rights. On this particular morning, Judge Brennan was home alone. His wife was visiting their daughter in another state. He had no criminal record, no outstanding warrants, and no reason to expect that his front door would be breached by a tactical team. The SWAT operation, according to the police report later released, the Metro County SWAT team had obtained a no-knock warrant for 4785 Maple Drive. The warrant authorized them to enter without announcing themselves because, investigators claimed, the suspect was believed to be armed and dangerous. The target of the warrant was a man named Marcus Williams, who was wanted on drug trafficking charges. Intelligence reports suggested Williams might be armed and had made statements about not being taken alive. Based on this information, the judge who issued the warrant had approved the no-knock entry. However, several details about the planning raised questions among observers. The raid was planned for early morning, a common tactic that law enforcement sources say is meant to catch suspects off guard. But critics of such tactics argue that early morning raids on sleeping families create unnecessary danger and chaos. The SWAT team consisted of 12 officers in full tactical gear. They had flashbang grenades, automatic weapons, and battering rams. For a single drug suspect, some commentators later questioned whether such overwhelming force was necessary. The address mix-up, how the address confusion happened, became a central point of controversy. The warrant clearly stated 4785 Maple Drive, but the team went to 4758 Maple Drive, a transposition of the last two digits. Some observers pointed to several concerning factors. First, 4758 and 4785 Maple Drive were only 4 houses apart on the same street. Second, both were similar-looking two-story suburban homes. Third, according to later reports, the raid was planned hurriedly, with some team members saying they had received the briefing just hours before the operation. Several retired police officers interviewed by media outlets suggested that proper planning should have included surveillance photos, confirmation of the target's vehicle, and visual verification of the address. None of these steps appeared to have been taken in this case. When asked by reporters, the police department initially stated that address errors are extremely rare and that they were investigating how this happened. Critics countered that extremely rare wasn't good enough when such mistakes could cost innocent lives. The constitutional issues legal experts immediately began weighing in on the constitutional implications. The Fourth Amendment protects citizens against unreasonable searches and seizures. A warrant must particularly describe the place to be searched. Going to the wrong address many constitutional scholars argued, rendered the entire search illegal, no matter how valid the original warrant was. Some legal commentators pointed out the irony. Judge Brennan had spent his career protecting Fourth Amendment rights. Now he was experiencing a Fourth Amendment violation firsthand, in the most traumatic way possible. Civil rights advocates noted that this case highlighted broader concerns about no-knock warrants. Several high-profile cases in recent years had involved wrong-address raids, sometimes with fatal consequences. Innocent people had been killed by police who burst into the wrong homes, and police officers had been killed by homeowners who thought they were being invaded by criminals. The debate over these tactics had been growing for years. Some argued they were necessary for officer safety in dangerous situations. Others contended that they violated constitutional principles and created more danger than they prevented. The initial entry, according to Judge Brennan's later testimony, he was asleep when the raid began. The first thing he heard was an explosion, the flashbang grenade. He described being disoriented, his ears ringing, unable to see clearly through the smoke and bright light. Within seconds, according to his account, armed figures in tactical gear were in his bedroom shouting commands. He said he had no idea who they were or what was happening. His first thought, he later told reporters, was that he was being attacked by home invaders. The judge stated that he initially reached for his legally owned handgun in his bedside table, a detail that would later fuel intense debate. He said that before he could even touch it, officers tackled him to the ground. He was 58 years old, 5'9", and weighed about 170 pounds. Multiple armored officers pinned him face down on his bedroom floor. "I thought I was going to die," he later told a news interviewer. "I had no idea these were police officers. It was chaos and violence, and I genuinely believed my life was ending." Body camera footage later released by the department showed the operation from the officers' perspective. The video showed them moving through the house with weapons drawn, shouting, "Police! Search warrant!" But Judge Brennan maintained he never heard those words over the noise of the flashbang and the ringing in his ears. The realization, according to multiple accounts, it took approximately 8 minutes before someone realized the error. An officer checking the house found mail addressed to Judge Thomas Brennan at 4758 Maple Drive. Another officer noticed family photos on the wall that didn't match the suspect's description. The team leader, according to reports, radioed back to command to verify the address. That's when someone checked the warrant again and discovered the mistake. Judge Brennan described the moment when an officer approached him, still zip-tied on the floor, and said, "Sir, I think we might be at the wrong address." "You think?" the judge recalled responding, his voice rising. "You just broke into my house, threw grenades, pointed guns at me, and you think you might be at the wrong address." Video footage reportedly shows officers beginning to realize the magnitude of their error. Some observers who viewed the footage noted that the officers appeared to become noticeably more nervous once they understood they had just raided a federal judge's home. The confrontation escalates. What happened next, according to various accounts, became heated. Judge Brennan, once the zip ties were removed, reportedly demanded answers. Witnesses later described him as furious but controlled, using his courtroom voice to demand explanations. "How does this happen?" he reportedly asked repeatedly. "How do you get an address wrong? How do you not verify before you break down someone's door?" The team leader, according to reports, tried to apologize. But Judge Brennan, according to witnesses, wasn't interested in apologies at that moment. He wanted accountability. Some observers noted that Judge Brennan's legal knowledge made the situation particularly tense for the officers. He knew exactly what laws had been broken. He knew the constitutional violations that had occurred, and he had the authority and credibility to hold them accountable. According to later testimony, Judge Brennan stated clearly, "I am a federal judge. You have just conducted an illegal search of my home. You have violated my Fourth Amendment rights. Every one of you should be very concerned about what happens next." One officer reportedly responded, "Sir, this was an honest mistake." Judge Brennan's response, according to witnesses, "An honest mistake? You could have killed me. If I had got to my gun, I might have shot at you thinking you were intruders. You might have shot me thinking I was the suspect. Your honest mistake could have ended with someone dead." The standoff for approximately 30 minutes, according to reports, Judge Brennan refused to let the officers leave. He demanded that supervisors respond to the scene. He insisted that photographs be taken of the damage to his home. He required that every officer provide their names and badge numbers. Some legal experts later commented that Judge Brennan was essentially treating his own home as a crime scene, which, legally speaking, it was. The unlawful entry, they noted, constituted criminal trespass and potentially other crimes. The SWAT team leader reportedly called his superiors multiple times. According to sources, there was significant concern at the command level about how to handle the situation. They had just raided a federal judge's home. The implications were enormous. When supervisors arrived, according to reports, Judge Brennan demanded a formal incident report be filed immediately. He insisted on speaking to the police chief, and he made clear that he would be filing a formal complaint and potentially a lawsuit. Throughout this confrontation, observers later noted, Judge Brennan demonstrated remarkable restraint. Despite being a victim of what many legal scholars called a clear constitutional violation, he did not become violent or irrational. He used his legal knowledge and judicial authority to ensure accountability. The story breaks when news of the raid became public. The response was immediate and intense. Legal commentators across the political spectrum weighed in, and the story dominated news cycles for days. Civil rights advocates seized on the case as a perfect example of why no-knock warrants are dangerous. If this can happen to a federal judge, one prominent activist stated, imagine what happens to ordinary citizens who don't have the power to demand accountability. Police unions and law enforcement advocates had a more complicated response. Some defended the officers, arguing that address mistakes, while inexcusable, are human errors that can happen in high-pressure situations. Others quietly acknowledged that this case highlighted serious problems with current practices. Social media erupted with commentary from all sides. Many users expressed outrage at the violation of Judge Brennan's rights. Others debated whether this incident would have received the same attention if the homeowner hadn't been a federal judge. Several commentators noted the racial dimension that was absent from this case but present in many similar incidents. Judge Brennan is a white federal judge, one analyst wrote. He'll get justice. But how many black and brown families have experienced similar raids with no accountability? The department's response, the Metro County Police Department, held a press conference 2 days after the incident. The police chief, visibly uncomfortable, acknowledged the error and apologized to Judge Brennan. "This should not have happened," the chief stated. "We are conducting a full investigation into how this address error occurred and what failures in our planning and execution allowed it to happen." However, the chief initially resisted calls for immediate policy changes. When asked whether the department would suspend no-knock warrants pending the investigation, he declined, stating that such warrants were necessary tools for officer safety in dangerous situations. This response drew criticism from civil liberties groups, who argued that the department was more concerned with defending its practices than with preventing future violations. Judge Brennan himself gave a brief statement to the press. "I have spent 25 years on the bench protecting constitutional rights," he said. "I never imagined I would experience such a violation personally. This experience has reinforced my commitment to ensuring that law enforcement operates within constitutional boundaries." The legal community's response was particularly notable. Judges across the country, according to media reports, were privately discussing the case. Some reportedly expressed sympathy for Judge Brennan and concern about the implications for judicial independence. Several legal organizations issued statements. The American Civil Liberties Union called for a federal investigation. The National Association of Criminal Defense Lawyers demanded policy changes. Even some prosecutors' associations acknowledged that the incident raised serious questions about current practices. A few judges publicly called for reforms to no-knock warrant procedures. One federal judge in another jurisdiction wrote an op-ed stating that he would no longer approve no-knock warrants except in the most extreme circumstances, citing Judge Brennan's case as evidence of the dangers these warrants pose. The political responses fell along predictable lines, though with some unexpected nuances. Conservative commentators who typically support law enforcement found themselves in an awkward position. Many expressed sympathy for Judge Brennan while still defending police in general. Progressive activists used the case to push for broader police reforms. Some argued that if this could happen to a powerful federal judge, it proved the need for systemic changes to protect all citizens. Interestingly, some observers noted, This case created unusual alliances. Some conservative libertarians who normally disagreed with progressives on police issues found common ground in opposing no-knock warrants as government overreach. The police department's internal investigation took 3 months. According to the final report, the address error was attributed to multiple system failures. The officer who prepared the briefing materials had transposed the digits. The team leader had failed to verify the address against satellite imagery or recent surveillance. The command staff had approved the operation without adequate review. 3 officers received written reprimands. The team leader was suspended for 30 days without pay. But no officers were fired or criminally charged, a decision that disappointed civil rights advocates. The department announced new policies requiring multiple verification steps before any no-knock raid. They mandated surveillance photos of the target address. They required command staff approval at higher levels, and they promised enhanced training on address verification. Critics argued these changes, while welcome, should have been in place all along. Why did it take raiding a federal judge's home to implement basic safety measures? One activist asked. Judge Brennan filed a federal civil rights lawsuit against the police department seeking damages and policy changes. Legal experts noted that, as a federal judge, he recused himself from hearing the case, which was assigned to another judge in the district. The lawsuit alleged violations of his Fourth Amendment rights and sought both compensatory and punitive damages. More importantly, it demanded court-ordered reforms to the department's warrant execution procedures. The case was closely watched by legal scholars because it would test the boundaries of qualified immunity, the doctrine that often shields police officers from civil liability. Some legal commentators predicted that Judge Brennan's status and legal expertise would make it difficult for the department to hide behind qualified immunity defenses. After 8 months of litigation, the case settled. Terms were confidential, but sources close to the case suggested the settlement included both monetary damages and agreements to implement specific reforms. The department agreed to a consent decree requiring outside monitoring of their SWAT operations for 3 years. The broader impact the case had ripple effects beyond Metro County. Several other jurisdictions reviewed their no-knock warrant policies in response to the publicity. At least 5 major cities announced they would restrict or ban such warrants except in the most extreme circumstances. Legislative responses varied by state. Some state legislatures introduced bills requiring stricter standards for no-knock warrants. A few states passed laws mandating body cameras during all SWAT operations. Others created civilian oversight boards with authority to review tactical operations. However, police unions in many jurisdictions fought these reforms, arguing they would endanger officer safety. The debate continued to divide communities and lawmakers. Judge Brennan's perspective in a law review article published a year after the incident, Judge Brennan reflected on the experience. He wrote that being on the receiving end of a constitutional violation had given him new insight into the terror and helplessness citizens feel when their rights are violated. For years, I ruled on cases involving search and seizure from the bench, he wrote. I understood the legal principles intellectually, but experiencing a violent, unlawful entry into my home gave me a visceral understanding of why these constitutional protections exist. He used his platform to advocate for reforms. He gave speeches at legal conferences. He testified before legislative committees. He became an unlikely voice for police reform, lending his conservative credentials and judicial authority to arguments often associated with progressive activists. Some observers noted the irony. The police raid had created one of their most effective critics, a federal judge with personal experience and the platform to demand change. What changed and what didn't 2 years after the incident, assessments of its impact were mixed. On one hand, several concrete reforms had been implemented in multiple jurisdictions. Training had improved, oversight had increased. Some departments had abandoned or severely restricted no-knock warrants. On the other hand, many observers noted that systemic problems remained. Wrong address raids continued to happen, though perhaps less frequently. Accountability for officers who made mistakes remained inconsistent. And the broader debates about police tactics and constitutional rights continued to divide the country. Civil rights advocates pointed out that Judge Brennan's case received attention because of who he was. Countless similar incidents involving ordinary citizens, they noted, never made headlines and resulted in no reforms. The lessons for those following the case. Several lessons emerged. First, many commentators noted that even the most powerful people are vulnerable to government overreach. If a federal judge's rights could be violated so dramatically, any citizen could experience similar treatment. Second, the case highlighted the importance of accountability systems. Judge Brennan got justice partly because he had the knowledge, resources, and platform to demand it. The challenge, advocates argued, was ensuring similar accountability when victims lack those advantages. Third, observers noted that the incident demonstrated the danger of prioritizing tactics over rights. The SWAT team's focus on surprise and overwhelming force led them to skip basic verification steps, with potentially catastrophic consequences. Fourth, some legal scholars argued that the case proved the wisdom of the Fourth Amendment's protections. The founders created these safeguards precisely to prevent government agents from breaking into homes without proper justification and careful execution. Finally, many commentators reflected on what might have happened if things had gone differently. If Judge Brennan had reached his gun and fired at what he thought were home invaders, he might be dead. If officers had shot him thinking he was the armed suspect, the tragedy would have been compounded. The fact that no one was killed, they noted, was largely luck. Moving forward 3 years after the raid, Judge Brennan remained on the federal bench. He continued to rule on cases involving search and seizure, though now with a personal perspective that few judges could claim. The Metro County Police Department maintained that it had learned from the incident and improved its procedures. Whether those improvements were sufficient remained a matter of debate. The broader conversation about police tactics, accountability, and constitutional rights continued. Judge Brennan's case became a reference point in those debates, cited by advocates on multiple sides as evidence for their positions. Perhaps the most significant legacy, some observers suggested, was simply that the story became known. In a nation where countless wrong-address raids occurred with little public attention, this one incident, because of who it happened to, forced a reckoning with practices that might otherwise have remained unexamined. If this commentary made you think about important issues like police accountability and constitutional rights, hit that like button and subscribe to our channel for more in-depth analysis of stories that matter. Drop a comment sharing your thoughts. What reforms do you think are necessary to prevent incidents like this? How do we balance officer safety with constitutional rights? Thanks for watching, and remember, these aren't just legal abstractions. These are real rights that protect real people. See you in the next video.